the way the thing is configured there. Good morning.
Good morning.
The Judiciary Committee will come to order, and without objection, the chair is authorized to declare a recess at any time. Pursuant to notice, I now call up H.R. 732 for purposes of markup and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 732, to limit donations made pursuant to settlement agreements to which the United States is a party and for other purposes.
Without objection, the bill is considered as read and open for amendment at any time. I'll begin by recognizing myself for an opening statement. Last Congress, this committee commenced a pattern or practice investigation into the Justice Department's mortgage lending settlements. We found that the Department of Justice is systematically subverting Congress's spending power by requiring settling parties to donate money to activist groups. In its last 2 years, the Obama Justice Department directed nearly $1 billion to third parties entirely outside Congress's spending and oversight authority. In some cases, these mandatory donation provisions reinstated funding Congress specifically cut. The spending power is one of Congress's most effective tools in reining in the executive branch. This is true no matter which party is in the White House. A Democrat-led Congress passed the Cooper-Church Amendment to end the Vietnam War. More recently, bipartisan funding restrictions blocked lavish salary and conference spending by federal agencies and grantees. This policy control is lost if the executive gains unilateral authority over spending. Serious people on both sides of the aisle understand this. A former Deputy Assistant Attorney General for the Office of Legal Counsel in the Clinton administration warned in 2009 that DOJ, quote, has the ability to use settlements to circumvent the appropriations authority of Congress, end quote. In 2008, a top Republican DOJ official restricted mandatory donation provisions because they, quote, can create actual or perceived conflicts of interest and or other ethical issues, end quote. Any objections to this bill will be unfounded. Whether the beneficiaries of these donations are worthy entities is entirely beside the point. The Constitution grants Congress the power to decide how money is spent, not DOJ. This is not some esoteric point. It goes to the heart of the separation of powers theory and Congress's ability to rein in executive overreach in practice. Nor does the bill restrict prosecutorial discretion. That discretion pertains to the decision to prosecute. Setting penalties and remedial policy is the proper purview of Congress. Opponents' central concern is that there may be cases of generalized harm to communities that cannot be addressed by restitution. But this misses the fundamental point. DOJ has authority to obtain redress for victims. Federal law defines victims to be those directly and proximately harmed by a defendant's acts. Once those victims have been compensated, deciding what to do with additional funds extracted from defendants becomes a policy question properly decided by elected representatives in Congress, not agency bureaucrats or prosecutors. It is not that DOJ officials will always be funding bad projects. It is that, outside of compensating actual victims, it is not their decision to make. Rather than suspend the practice of mandatory donations in response to these bipartisan concerns, the Obama Justice Department doubled down. DOJ's recent settlement with Volkswagen, requiring the company to spend $2 billion to fund an Obama administration electric vehicle initiative for which Congress had twice refused to pay, is an example in point. DOJ's January 18, 2017 settlement with Credit Suisse required the bank to spend $240 million credit financing affordable housing projects. Because the projects must be financed at below market rates, the bank is given credit for the losses associated with the financing. In other words, the financing is effectively a donation in the guise of a loan. It's time for Congress to end this abuse. The Stop Settlement Slush Funds Act of 2017 bars mandatory donation terms in DOJ settlements. It is a bipartisan bill. It makes clear that payments to provide restitution for actual harm directly caused, including harm to the environment, are permitted. Don't be fooled by opponents' scare tactics. They claim that the legislation could prohibit conduct remedies used in settlements covering workplace discrimination, harassment, and consumer privacy. The bill does not preclude such remedies. Nothing bars DOJ from requiring a defendant to implement workplace training and monitoring programs. The ban on third-party payments merely ensures that the defendant remains responsible for performing these remedies itself and is not required to outsource set sums for the work to third parties who might be friendly with a given administration. This bill addresses an institutional issue. That is one reason similar language passed the House last Congress by voice vote. I thank all of the bill's co-sponsors and I urge its passage. And it's now my pleasure to recognize the ranking member of the Judiciary Committee, Mr. Conyers of Michigan, for his opening statement.
Thank you, Chairman Goodlatte. H.R. 732 would prohibit the federal government from entering into or enforcing any settlement agreement requiring donations to remediate harms that are not, quote, directly and proximately, in quotation, caused by a party's unlawful conduct. This is problematic for several reasons. To begin with, the bill would prohibit these types of settlement agreements even though they have been successfully used to remedy various harms, particularly those caused by reckless corporate actors. For example, these settlement agreements helped facilitate an effective response to predatory and fraudulent mortgage lending activities of financial institutions that nearly caused the economic collapse of our nation and that led to the Great Recession. In fact, settlement agreements with two of these culpable financial institutions, the Bank of America and Citigroup, required a donation of less than 1% of the overall settlement amount to fund foreclosure prevention and remediation programs to help affected consumers, less than 1%. Contrary to the majority's claim, the Justice Department did not use any of these settlement agreements to fund activist groups. Notwithstanding the production of hundreds of pages of documents by the Justice Department, along with hundreds of pages of documents produced by private parties, we have not seen any evidence that the government included unlawful or politically motivated terms in its settlement agreements with Bank of America or Citigroup. The majority also asserts that these settlement agreements are used by the Justice Department and other agencies to circumvent the congressional appropriation process. But existing law already prevents agencies from augmenting their own funds by requiring that donations included in settlement agreements have a clear nexus to the prosecutorial objectives of the enforcement agency. And both the Government Accountability Office and the Congressional Research Service have concluded that settlement agreements providing for secondary remediation do not violate Congress's constitutional power of the purse. Finally, I'm also concerned that H.R. 732 would have harmful consequences on the remediation of systemic harms in civil and criminal enforcement actions. I think that's very, very important. These settlement agreements allow parties to resolve their civil or criminal liability by voluntarily remediating the harms caused by their unlawful conduct. For some types of unlawful conduct, such as discrimination based on race or religion, secondary remediation of harms may be the only remedy available for systemic violations of the law, as they typically affect the interests of individuals who are not themselves party to the underlying action. Secondary remediation in the form of voluntary compliance and training programs, for example, serve as an important tool in these cases to protect victims of discrimination. So given these concerns and others presented by the bill, I am still in very firm opposition to H.R. 732. Thank you, Mr. Goodlatte. I yield back.
Thank you, Mr. Conyers, and I'd now like to recognize the gentleman from Rhode Island, Mr. Cicilline, for his opening statement.
Thank you, Mr. Chairman. It's only been days since President Trump's shameful decision to fire Acting Attorney General Sally Yates for her courageous stand against the unconstitutional Muslim ban, and yet we now are considering yet another Republican proposal that would undermine the enforcement discretion of career Justice Department attorneys. H.R. 732, the inaptly titled Stop Settlement Slush Funds Act of 2017, would flatly ban the enforcement of any settlement agreement that seeks to remedy the general harm caused by unlawful conduct. This prohibition would broadly apply to all civil and criminal settlements, with limited exception, encroaching on the Justice Department's long-standing legal authority to negotiate and enter settlement agreements. Since its establishment in 1870, the Justice Department has possessed plenary authority to litigate on behalf of the government in all civil and criminal litigation, except as otherwise provided by law. Since at least as early as 1888, the Supreme Court has upheld this broad grant of authority. Since then, the court has also held that this authority extends to settling litigation on behalf of the government or making enforcement decisions in light of priorities and resources. In Heckler versus Cheney, for example, the court held in 1985 that in many cases, enforcement decision within the Justice Department's expertise make it, quote, far better equipped than the courts to deal with the many variables involved in the proper ordering of its priorities, end quote. This rationale also extends to the terms of settlement agreements, which, quote, involve numerous complicated technical issues, as well as important judgments with respect to the use of limited prosecutorial resources, and are best left in the hands of expert agencies and prosecutors rather than dictated by Congress or the federal courts, as environmental law expert Professor Joel Mintz has noted. H.R. 732 upends this long-standing policy by strictly curtailing the enforcement discretion of the Justice Department and other enforcement agencies when resolving a party's civil or criminal liability on behalf of the federal government. As the Justice Department observed last Congress in the context of a substantially similar legislation, limiting the department's discretion to negotiate appropriate terms of settlement, which are voluntary and agreed to by the parties, may result in fewer settlement agreements, protracted litigation, and delays for victims who need the relief, end quote. Without this discretionary authority, the department concluded that the government may not be able to adequately address the full scope of the harms that a defendant's illegal action caused. It's therefore not surprising that this legislation is opposed by a broad coalition of public interest organizations, including Americans for Financial Reform, Public Citizen, the National Fair Housing Alliance, and the National Urban League, which stated in opposition to a substantially similar version of this bill considered last Congress that it would, quote, undermine law enforcement goals by reducing the availability of suitable remedies to address these kinds of injuries to the public caused by illegal conduct. Mr. Chairman, despite investigating the Justice Department's use of settlement agreements for over 2 years, this committee has not uncovered any evidence indicating a lapse in judgment or a misuse of discretion by the Justice Department or any other enforcement agency for that matter. To the contrary, we've learned from the nonpartisan Congressional Research Service, as well as experts in civil and criminal law, that the Justice Department under President Obama did not violate current law in any of the settlement agreements that have been the subject of congressional oversight. The bill before us would prohibit settlement agreements that authorize payments to parties not directly and proximately harmed by the unlawful conduct of a settling defendant. In doing so, H.R. 732 would undermine the ability of agencies to adequately address unlawful conduct, provide complete restitutions for violations of the law, and tailor remedies to address systemic or diffuse harms to unidentifiable victims, the public health, or the environment. Passage of this bill will make our system of justice less effective, less responsive, and less just. And I urge my colleagues to oppose this measure and yield back the balance of my time.
Chair thanks the gentleman. I now recognize myself for purposes of offering an amendment. The clerk will report the amendment.
Amendment to H.R. 732, offered by Mr. Goodlatte of Virginia. Page 2.
Without objection, the amendment will be considered as read, and I will recognize myself to explain the amendment. This amendment addresses DOJ's shift in tactics late in the Obama administration. Facing increased scrutiny for mandatory donation terms, DOJ began forcing settling defendants to provide financing for various projects. These loans may well be unprofitable, so defendants are given credit for losses associated with providing the financing. As such, these settlement provisions are essentially donations in the guise of loans. For example, DOJ's January 18, 2017 settlement with Credit Suisse required the bank to spend $240 million credit dollars financing affordable housing projects. The bank was given credit for the associated loss, which the settlement defines as the difference between the amount provided to the borrower and the estimated future cash flows from the loan, applying an appropriate discount rate. This amendment would strengthen the bill by preventing DOJ from using donations in the guise of loans to circumvent the bill's restrictions. I urge my colleagues to support it. For purposes, gentleman from Michigan, seek recognition.
Thank you, Mr. Chairman. I
Gentleman's recognized for 5 minutes.
regretfully have to oppose the chairman's amendment because this amendment expands the bill to prohibit loans as a form of payment under a civil or criminal settlement agreement, which would make this already problematic bill even worse, in my view, by prohibiting the use of loans as a form of payment under settlement agreements. Now, under the consumer relief provisions of the Justice Department, settlements with banks that mislead investors about toxic mortgage securities, settling banks may satisfy their obligations under the settlements by providing payment mortgage loan forgiveness to distressed borrowers. It is unclear how this form of payment, which provides for purposes of modifying oftentimes predatory mortgages, issued by the unscrupulous and lawful activity of the settling banks is a form of indirect payment, let alone a slush fund. Importantly, the terms of these loan modifications are subject to audit by an independent monitor to ensure that the settling banks actually make consumers whole. Loan modifications are an important aspect of these settlements because they have been concerning reports in the past about lenders' non-compliance with mortgage modification programs, such as the Home Affordable Modification Program, popularly known as HAMP, which provides relief to certain distressed homeowners to avoid foreclosures through mortgage modification. For example, in December 2013, Bloomberg reported that Bank of America, the second largest lender and one of the banks that settled with the Justice Department, faced more than 15,000 complaints in 2010 alone relating to servicing under HAMP for unscrupulous conduct, such as stalling homeowners with repeated paperwork requests and incorrect income calculations, which then led to more expensive modifications with additional fees due to these delays. Bloomberg also reported that Bank of America rewarded staff with cash bonuses and gift cards for meeting quotas tied to sending distressed homeowners into foreclosure. Former employees said this in court documents. Accordingly, it is clear to me that the consumer relief provisions of these settlements should provide for loan forgiveness and other forms of relief to adequately remedy the effect of the settling bank's unlawful conduct. And so I urge opposition to this amendment, and I yield back, Mr. Chairman.
Would the gentleman yield?
Certainly.
I thank the gentleman. I just want to make clear that this does not affect the refinancing of loans of the victims in a lawsuit brought by the Justice Department or anybody else for that matter in government, but rather is directed at new loans that are to third parties that are not parties to the lawsuit, not victims of the crime that's ongoing. So that's the purpose of the amendment, and it does not interfere with the ability of the government to, as a settlement of a case with a bank, direct that the terms and conditions of an existing loan of one of the victims or more victims be restructured. And I thank the gentleman.
Mr. Chairman, I move to strike last word.
For what purposes? The gentleman is recognized 5 minutes.
Thank you, Mr. Chairman. I also am in opposition to this amendment for all reasons that our distinguished ranking member stated. But I do also want to say, Mr. Chairman, that I'm new to this committee. I pushed very hard to be on this committee, specifically because I believe so deeply in the importance of this committee's jurisdiction to our nation's founding ideals and to our future. And therefore, I must say that I am quite dumbfounded that we are marking up this bill at a time when this president is rapidly rolling out executive orders that have turned our immigration system upside down and have resulted in fundamental rights violations, and at a time, frankly, Mr. Chairman, when the president is tweeting his disdain for an independent judiciary. It seems that this president is not interested in a system of checks and balances and seems to believe that he is the sole determinant of who threatens this country, whether based on fact or fiction and regardless of people's constitutional rights. This committee, Mr. Chairman, the Judiciary Committee, should be discussing these enormous and real questions that are before this country at this time instead of manufactured solutions to manufactured problems. No less than 5 federal judges have ruled against the president's executive orders. Last Friday, U.S. District Judge James Robart, appointed by Republican President George Bush, issued a nationwide stay on one of the executive orders, finding that the states, quote, face immediate and irreparable injury as a result of the signing and implementation of the executive order, end quote. In addition, he found that the order adversely affects employment, education, business, family relations, and freedom to travel, and that, quote, these harms are significant and ongoing. I am very proud that this decision resulted from the hard work of my state's Attorney General in Washington State, Bob Ferguson, and his team. I cannot overstate the ongoing harm that these executive orders are having on the men, women, and children in my district and state. I've heard from people who are terrified, and I'm not just talking about immigrants and refugees, but also U.S. citizens and legal permanent residents who should have nothing to fear when it comes to their rights, who are afraid of rising Islamophobia and xenophobia. Even after Judge Robart's nationwide stay, I received numerous calls from people who should be able to enter the country, but are frightened that they still are not being allowed back. And just yesterday, one of my constituents, Isahik Rabi, was finally reunited with his U.S. citizen wife. He first landed in Seattle over a week ago, right after the president released his executive order. And what should have been a joyful reunion turned into a nightmare. Customs and Border Protection quickly put him on a plane without his papers and without due process. After Judge Robart in my hometown ordered a nationwide halt to the travel ban, Mr. Rabi and his attorney quickly began the process of coming back. And my CBP and the State Department staff and my staff worked late into the night this weekend on Saturday to actually get him back into the United States. Instead of fighting the nationwide stay in court and showing disdain for the judiciary, the administration should be exhausting its resources to reverse the harmful impacts of its misguided executive order. And this committee, Mr. Chairman, should be doing everything in our power to check the administration on its unconstitutional actions and implement the real purposes of the Judiciary Committee. I yield back the balance.
Would the gentleman yield? Would the gentleman yield?
Yes.
I thank you for yielding. I just want to make it very clear that your concern about protecting the Article I powers of the Congress is well taken, which should mean you should support this bill and this amendment, because that's exactly what this does. It checks abusive power used by the executive branch, and not just the prior administration, but the current administration as well. So I'd encourage you to support the bill, because it does exactly what you're concerned about, and that is to check a power that the executive branch does not have when it tries to subvert the actions of the Congress and tries to go around the Congress by appropriating funds that the Congress should be more appropriately appropriating. So I thank you for your comments.
Mr. Chairman, if I may respond, what I would say is that, first of all, it does not answer the question of why this committee is not responding to the crises that we have in the country before us. But secondly, Mr. Chairman, I would argue that the amount of money that has been put into these settlement funds, and they're not slush funds, but settlement funds to respond to the deep needs of our populations who were adversely affected by the mortgage crisis, require that we actually take different routes to make sure that those communities are being addressed. That is what these settlement funds do, Mr. Chairman. I yield back.
Move to strike last word.
Chair recognizes the gentleman for 5 minutes.
Yield my time to the chair.
Thank you. Well, I just want to make very clear that that's the position that you're taking, that when the executive branch sees a need to do something that a particular administration finds to be a priority, then I'm very, very concerned about your position that we're not addressing the appropriate things that are going on in administration, because it's absolutely clear to me that the prior administration and future administrations as well could abuse their power and supplant the decision-making power of the Congress by appropriating funds that they have no business appropriating, because they're not related to victims of the lawsuits they're handling, but rather to third parties that may be favored groups of people or favored causes that they have. And so as a result of that, it would be my hope that we would look ahead at the concerns that were raised during the last Congress, and given the fact that there's been a change of administration, take advantage of the opportunity to put a check against this administration, future administrations, from supplanting the power of the Congress, and in fact, pass legislation like this that would assure us all that the Article I powers will be preserved, and that the Congress is going to take back those powers. Bipartisan support for this legislation, which there is some but not enough, would be a very, very helpful thing in laying the groundwork for making sure that Congress asserts its Article I powers. I yield back to the gentleman.
Thank you. Reclaim my time. I yield back.
Thank you. The question occurs on the amendment. All those in favor? All those in favor respond by saying aye. Those opposed, no.
No.
In the chair, the ayes have it. The amendment is agreed to. Are there further amendments?
I have an amendment at the desk.
The clerk will report the amendment.
Amendment to H.R. 732 offered by Mr. Conyers. Page 2, line 6, insert after settlement agreement the following, except as provided in subsection G. Add at the end of the bill the following.
Without objection, the amendment is considered as read, and the gentleman is recognized for 5 minutes on his amendment.
Thank you very much. Members of the Judiciary Committee, my amendment would exempt from the bill settlement agreements that direct funds to remediate the indirect harm resulting from the presence of lead in public drinking water caused by unlawful conduct. This is to me, a very common sense issue. And according to the Environmental Protection Agency, there is no safe level of exposure to lead. And we go to Flint, Michigan. The Flint, Michigan water crisis clearly illustrates the disastrous consequences of lead contamination in public drinking water, which has had both direct and indirect harmful effects on the unsuspecting citizens of this municipality. As a pediatric doctor in Flint observed, to understand the contamination of this city, think about drinking water through a straw coated in lead. As you sip, lead particles flake off into the water and are ingested. Flint's children have been drinking water through lead-coated straws. Unfortunately, the Flint water crisis is not just an isolated circumstance. A report from the American Water Works Association estimates that millions of water service lines may be leaching lead into our drinking water. To resolve civil and criminal liability for lead contamination in drinking water concerning the Flint water crisis, for instance, settlement agreements may require funds to be set aside to address various indirect harms. These would include compensating unidentifiable victims, directing payments to address generalized harm, or funding remediation efforts, such as environmental compliance programs to avoid lead contamination in the future. Unfortunately, the measure under consideration, H.R. 732, would prohibit these forms of general remediation. As Nova Southeastern University College of Law professor and former chief attorney at the Environmental Protection Agency, Joel Mintz, warns, H.R. 732 would prohibit entirely legitimate and appropriate uses of settlement funds permitted under current laws, such as environmental restoration projects or facility assessments and audits. Opponents of this bill argue that requiring civil penalties be paid directly to the U.S. Treasury would enable Congress to best decide how to allocate compensatory funds. Yet, Congress has already passed environmental laws that expressly provide for these forms of secondary relief. And as courts have routinely noted, the purpose of these laws is to improve water quality, not endow the Treasury. Moreover, Congress lacks the time, expertise, and resources to review and make enforcement decisions on behalf of federal agencies. Lead contamination in public drinking water is a nationwide public health crisis. Congress cannot simply make individual appropriations in response to each instance of general harms caused by lead contamination in public drinking water. The cost, delay, and overall folly of this scheme would have a disastrous impact on public health and local communities. And so accordingly, I urge my colleagues to please support my amendment. And Mr. Chairman, I yield back the balance of my time.
Chair thanks the gentleman recognize himself in opposition to the amendment. I oppose this amendment because it misses the point. It would exempt settlements that direct funds to remedy indirect harm resulting from lead in drinking water. The amendment is for to focus on indirect harm because nothing in the bill prevents remediation of direct harm. But settlement provisions addressing indirect harm are precisely why this bill is needed. The bill's guiding principle is that once direct victims have been compensated, deciding the best use of additional funds extracted from defendants, whether that is addressing indirect harms or otherwise, is a policy question properly decided by the elected representatives in Congress, not agency bureaucrats or prosecutors. Congress recently appropriated $120 million to address drinking water problems in Flint, Michigan. If there is further need, Congress can make additional appropriations. The DOJ should not be permitted to augment these funding decisions entirely outside of the congressional appropriations and oversight process. The spending power is one of Congress's most effective tools in reining in the executive branch. This is true no matter which party is in the White House. This amendment would weaken that essential congressional power, and I urge my colleagues to oppose it on institutional grounds.
Mr. Chairman.
What purpose does the gentleman from Maryland seek recognition?
Thank you very much. I'd like to speak on the amendment.
The gentleman is recognized for 5 minutes.
Thank you very much, Mr. Chairman. And I would rise in support of the ranking member's amendment here because I think it makes a bill that is fundamentally misguided and unnecessary a little bit better. But just to refocus our attention on what's at stake here, we're still recovering from the effects of the worst financial crisis of our lifetime, Mr. Chairman. The subprime mortgage meltdown crisis, everything that followed, cost the American people more than $22 trillion in lost home equity, retirement savings, investments, and so on. And it was discovered during that period that a number of banks were engaged in illegal, fraudulent, and predatory practices towards their own clients. And so one of the ones that you mentioned in your opening statement, Mr. Chairman, was Credit Suisse, which ended up in a settlement agreement for more than $5.5 million. $2.48 million was given directly to victims in what you're describing as direct harm, and I think there was another $2.8 billion that was given to various groups to try to remediate the destructive effects of their predatory practices on affected communities. And a number of groups were given money in that process to engage in counseling of distressed homeowners and people who had lost their houses and were in foreclosure. We still have 2 million, more than 2 million American families that are in foreclosure today as a result of this process. So the legislation invites us to believe that there's this distinction that you're offering between direct harm and indirect harm. So the theory is that people who are directly thrown out of their houses because of the racially discriminatory steering of African American and Hispanic homeowners away from standard mortgages into the subprime market are the direct victims, so they can be compensated directly, but that the community organizations that work in their communities to try to counsel people generally and to try to restabilize the community after the effects of the recession are somehow off limits. Now, this is a novel proposition that is essentially is trying to take from the judicial remedial power and the power of parties negotiating a settlement a traditional function that has always been part of settlement agreements. And it's very unclear why we would want to do this. The mortgage foreclosure crisis and the meltdown affected not just people's individuals, but entire communities. And as we saw, for example, in the Credit Suisse example, racially discriminatory action that affected particular communities in a harder way. So the ability of the Department of Justice to engage in settlement agreements that steer some of the money to groups that are working to restabilize and to strengthen the communities is an essential part of the remedial function of both the courts and of the Department of Justice. We have not had a hearing on this in this committee in this session, so those of us new to the committee have not heard any testimony about it, but I did go back to look at the testimony that you saw in the last session, and I couldn't find any evidence that there was abuse of this in any way. There are already very strict and rigorous requirements imposed on groups that receive this money to make sure that they're not engaged in political activity or other unlawful actions. And so I think that this is a solution in search of a problem, and I can't understand why we would want to do this. So for that reason, I'm going to support the amendment, and I will end up opposing the underlying legislation. Thank you, Mr. Chairman. I yield back.
What does the gentleman from Rhode Island seek recognition?
Move to strike last word.
Gentleman recognized 5 minutes.
Mr. Chairman, I just want to respond. I know there have been a number of concerns raised by my colleagues on the other side of the aisle about what this is intended to address. As my distinguished gentleman colleague from Maryland said, this really is a Republican solution in search of a problem that doesn't exist and, frankly, is rife with unintended consequences. Long-standing appropriations law and agency policy, as recognized by the Government Accountability Office and the Congressional Research Service, prevent enforcement agencies from directing funds to politically favored groups or circumventing Congress's appropriations rule. That is already the rule. The Justice Department adopted rules in 2008 that required the Deputy Attorney General to approve appointments of monitors. They also banned deals requiring companies to make payments to outside groups that weren't harmed by the misconduct or that didn't address problems related to the misconduct. And so this is really a piece of legislation that is in search of a problem that doesn't exist, that will have devastating consequences. And I urge my colleagues not to view this sense of harm in such a limited way as the chairman has suggested. If you have a house that goes into foreclosure because of predatory lending, it obviously has an impact on that family. The harm is direct. But it also has an impact on that neighborhood, on that city, in terms of a reduction in taxes, or a reduction in revenue to the municipality, a likelihood of increased crime as houses become abandoned in the neighborhood, a depreciation of value of surrounding houses. And so this notion of that the only person harmed is the person who's the direct victim of the predatory lending is a very and unrealistic and too narrow view of the harm that these big banks caused on our communities, and to prevent courts in reaching settlement agreements to approve responding to that diffuse harm, I think is a big mistake. And so I continue to oppose this bill. I thank the ranking member for his excellent amendment, because this at least makes some improvement out of, I think, fatally flawed piece of legislation. The amendment has proposed exempt settlement agreements that direct funds to remediate the general harm caused by unlawful conduct that increases the amount of lead contamination in public drinking water. The Flint water crisis is an enduring and shameful reminder of the ramifications that underinvestment in our infrastructure and for local communities. Last year, Gina McCarthy, the administrator of the Environmental Protection Agency under President Obama, testified that, quote, across our country, water infrastructure is aging, it's antiquated, and it's severely underfunded, particularly in low-income communities, which may have most difficulty securing traditional funding through rate increases or municipal bond, end quote. Worse still, the effects of environmental catastrophes are more likely to impact vulnerable populations, which are more vulnerable to health impacts of pollution, while also lacking the tools and resources to do something about it, as Ms. McCarthy has noted. This amendment ensures that these populations are able to be fully compensated in cases involving lead contamination in public drinking water. Currently, H.R. 732 would prohibit the use of settlement funds to improve water treatment facilities, maintenance practices, facility audits, or to prevent additional water contamination at the source, according to Professor Joel Mintz, an environmental law expert. As Professor Mintz further observes, a slush fund is commonly defined as being used for illicit or corrupt political purposes. Environmental restoration projects cannot be fairly considered slush funds in any sense, end quote. Americans deserve access to safe drinking water. Without this amendment, H.R. 732 threatens this fundamental right by unnecessarily restricting the use of agencies' longstanding enforcement discretion to craft settlements to benefit local communities and to protect them from this kind of harm. And so I urge my colleagues to support this. I thank the ranking member for introducing this amendment, and with that, I yield back, Mr. Chairman.
Question occurs on the amendment offered by the gentleman from Michigan. All those in favor respond by saying aye. Aye. Those opposed, no. No. Opinion of the chair, the noes have it. The amendment is not agreed to.
May we have
A recorded vote is requested, and the clerk will call the roll.
Mr. Goodlatte?
No.
Mr. Goodlatte votes no. Mr. Sensenbrenner? Mr. Smith? Mr. Shabbat? Mr. Issa? Mr. Issa votes no. Mr. King? Mr. Franks? Mr. Franks votes no. Mr. Gomer? Mr. Gomer votes no. Mr. Jordan? Mr. Poe? Mr. Davids? Mr. Marino? Mr. Marino votes no. Mr. Gowdy? Mr. Gowdy votes no. Mr. Labrador? Mr. Barenfold? Mr. Collins? Mr. DeSantis? Mr. Buck? Mr. Buck votes no. Mr. Ratcliffe? Mr. Ratcliffe votes no. Mr. Bishop? Ms. Roby? Ms. Roby votes no. Mr. Gates? Mr. Johnson? Mr. Johnson votes no. Mr. Biggs? Mr. Biggs votes no. Mr. Conyers?
aye.
Mr. Conyers votes aye. Mr. Nadler? Mr. Nadler votes aye. Ms. Loughran? Ms. Jackson Lee? Mr. Cohen? Mr. Johnson? Mr. Johnson votes aye. Ms. Chu? Mr. Deutsch? Mr. Deutsch votes aye. Mr. Gutierrez? Ms. Bass? Ms. Bass votes aye. Mr. Richmond? Mr. Jeffries? Mr. Cicilline? Mr. Cicilline votes aye. Mr. Swalwell? Mr. Swalwell votes aye. Mr. Liu? Mr. Liu votes aye. Mr. Raskin? Ms. Jayapal? Ms. Jayapal votes aye.
Gentleman from Florida, Mr. DeSantis. The
Mr.
gentleman
DeSantis votes no.
Gentleman from Utah, Mr. Chaffetz.
Mr. Chaffetz votes no.
The gentleman from Ohio, Mr. Jordan.
Mr. Jordan votes no.
The gentleman from Michigan, Ms. Bishop.
Mr. Bishop votes yes.
Has every member voted who wishes to vote? The clerk will report.
Mr. Chairman, 10 members voted aye, 14 members voted no.
And the amendment is not agreed to. Are there further amendments to H.R. 732? For purpose, the gentleman from Georgia seek recognition.
I have an amendment at the desk.
The clerk will report the amendment.
Amendment to H.R. 732 offered by Mr. Johnson of Georgia. Page 2, line 6, insert after settlement agreement the following. Add at the end of the bill.
Without objection, the amendment is considered as read, and the gentleman is recognized for 5 minutes on his amendment.
Thank you, Mr. Chairman. My amendment would block this blanket prohibition on settlement agreements involving third parties from applying to cases involving indirect harms caused by unlawful conduct. In other words, this means when a bad actor, such as a polluter or a foreign car manufacturer, intentionally breaks the law and then enters into a settlement with the U.S. government, H.R. 732 does not apply. The most recent example would be aptly named Dieselgate, which is the most recent scandal involving Volkswagen cars. In the fall of 2015, the German car giant was found to have been cheating on its emission standards tests. Software installed in over 500,000 cars allowed the circumvention of the car's emissions control systems during laboratory testing conditions, thus allowing the vehicle to pass the test despite being non-compliant. In fact, an independent study found the emissions from the Volkswagen cars were 15 to 40 times higher than the EPA's compliance levels. This corporate cheating was in utter disregard for fundamental laws governing the sales of automobiles in this country and led to the company not only facing a significant class action lawsuit, but also a lawsuit by the EPA. As per the terms of the settlement, Volkswagen agreed to spend up to $14.7 billion to remediate the excess emissions. Most of this money went towards a significant vehicle buyback and repair program, but approximately $2.7 billion went into the Environmental Mitigation Trust. And I think this is what my friend on the other side of the aisle do not appreciate. This trust provides money to the states to fund clean transportation programs. The money is used to invest in zero-emission buses, the purchase of electric vehicles, and also to fund efforts to reduce emissions at port facilities. Almost every state has used funds from this trust to support various clean transportation programs. For example, the state of Virginia received over $87 million, Wisconsin over $63 million, Texas received a whopping $191 million, and Georgia has received over $58 million. I know zero-emission vehicle deployment has been an area of importance in the Atlanta region, and money the German company owes for breaking U.S. federal law could potentially be used towards such programs. Volkswagen's actions are even more egregious when you consider the fact that Volkswagen's executive chief, Oliver Schmidt, the company's former head of U.S. compliance, was arrested and charged with conspiracy to defraud the United States. It shows the sheer audacity of the company and the unprecedented level of fraud that took place. When companies, especially foreign companies, act this poorly, it is important that the American public has the opportunity to achieve justice. Settlement agreements that direct funds to remediate these harms give us that chance. My amendment will allow for such settlements to be exempt from H.R. 720. And with that, Mr. Chairman, I thank you and I yield back.
Your thanks, gentlemen. For purposes, gentleman from Colorado seek recognition.
To respond,
Gentleman recognized for 5 minutes.
I oppose this amendment because it misses the point. It would exempt settlements that direct funds to remedy indirect harm resulting from Clean Air Act and other violations. As the chairman explained earlier, settlement provisions addressing indirect harm are precisely the problem. How best to address indirect harm is a policy question properly decided by elected representatives in Congress, not agency bureaucrats or prosecutors. Indeed, the bill explicitly references the environmental context in which the injury to the environment may be diffuse and there may be no identifiable victims. The bill deals with this by explicitly permitting payments to remediate environmental damage. If direct remediation of the harm is impossible or impractical, the violator is not let off the hook. The full penalty is paid, but into the Treasury. It is simply that the decision as to what is the next best thing to do with the money is left to the people's elected representatives in Congress rather than the executive branch. Accordingly, I urge my colleagues to oppose this amendment, and I yield back.
First gentleman from Rhode Island seek recognition.
Seek time to support the amendment.
Gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman. I support this amendment precisely because it does not miss the point. It protects the ability of the court to approve settlement agreements that fashion remedies to respond to the actual damage caused by the misconduct actions of the defendants. Earlier this year, the Department of Justice and other enforcement agencies finalized settlement agreements with Volkswagen, an automobile manufacturer that defrauded the public since 2006 through the use of software to evade the emissions requirements of the Clean Air Act. According to independent research, the emission levels of Volkswagen cars were 15 to 40 times higher than the EPA's compliance level. According to documents filed in court, Volkswagen's engineers implemented software designed to evade U.S. emission tests to satisfy U.S. standards for nitrogen oxides. Volkswagen has pleaded guilty to both civil and criminal violations of federal statutes, including the Clean Air Act, by lying to the public and enforcement agencies concerning whether its vehicles complied with nitrogen oxide emission standards. According to the Sierra Club, these emissions are a powerful pollutant, having direct consequences on human and environmental health. People most at risk for breathing air containing ozone include people with asthma, children, older adults, and people who are active outdoors, especially outdoor workers. The company also pled guilty to destroying documents, making false statements to the public, and other statutory violations of the public's trust. Sally Yates, the former Deputy Attorney General, stated that this unlawful conduct, quote, wasn't simply the action of some faceless multinational corporation, but a conspiracy involving flesh and blood individuals who used their positions within Volkswagen to deceive both regulators and consumers, end quote. Only yesterday, the Federal Trade Commission finalized a settlement with German supplier Bosch, which provided Volkswagen with illegal software for its emission defeat devices. The New York Times has noted that the involvement of Bosch, one of the world's largest auto suppliers, underscores the broad nature of the diesel deception, which stretched beyond the car maker and involved dozens, if not hundreds of people for nearly a decade. As part of its settlement for knowingly incorporating software to cheat emission tests and defraud the public, Volkswagen has agreed to a settlement that includes $4.7 billion to remediate the excess nitrogen oxide emissions caused by its fraudulent conduct. Supplemental environmental projects such as this are a lawful use enforcement discretion that allows agencies and the settling party to offset the harms of unlawful emissions or discharges by requiring parties to undertake an environmentally beneficial project or activity. In a letter concerning the settlement, a group of public interest organizations encouraged the adoption of a SEP in response to Volkswagen's emissions scandal, quote, above and beyond other remedies, so automakers don't take the lesson that all they need to do to cure cheating is to pay money as a cost of doing business, end quote. This form of general environmental remediation would be prohibited by H.R. 732, which would ban the enforcement of settlements that direct funds to remediate the indirect harms of lawful conduct affecting consumers and the environment. At least this amendment would reverse that, and I urge my colleagues to support this very important amendment. And with that, I yield the balance of my time to Mr. Johnson.
Thank you. I thank the gentleman. Lawsuits in court seeking justice for direct and indirect harms are a time-honored means of forcing compliance with federal law. This bill muzzles that enforcement mechanism, takes it off the table. Why? Because my friends on the other side of the aisle want to do as much as they can to protect corporate polluters from accountability. Now, we already know that the criminal laws are not used to punish these white-collar criminals to the extent that they should, but we certainly have gotten after them with civil lawsuits. And why would we not want to use the civil justice process to achieve justice for environmental or for harm such as the one involving Volkswagen? Why wouldn't we want to do that? Well, I mean, there's just no reasonable explanation other than we want to protect corporate polluters, or at least my friends on the other side of the aisle want to do that. It's not wise. It's born of skepticism and outright hostility to this idea of climate change, which 95% of scientists will tell you that it's something, it's man-made, man contributes to it. This settlement or this legislation is another attack on science. And for that reason, I would ask that my colleagues support this amendment. And I yield back.
Question occurred on the amendment. For purpose of the gentleman from Texas seek recognition. Gentleman's recognized for 5 minutes.
I'm sorry, I won't be long, but when my friend says that his friends across the aisle want to protect corporate polluters, I got to respond to that. And I appreciate the position of my friend Mr. Johnson, but we're not looking to protect corporate polluters. We're looking to make sure that when there is a fine, when there is a settlement, that money goes where it should, instead of going to reward some group that's friendly in a political way. We have seen settlements where the government has had the proceeds go to groups that help elect Democrats when it could have better gone to remedy a problem directly. Look, if there's been corporate polluters and they're responsible, have that money go directly to the United States Treasury. But to direct that money to go anywhere but the U.S. Treasury, well, actually in Texas, that would be a crime to help it go to any group that might help people in your party to be elected. I just find it surprising that there would be opposition to saying that money goes to the U.S. Treasury so Congress can decide where it should go instead of unelected people in the Justice Department. A good example I'll give to you was Ronnie Earl, the district attorney in Texas. Nobody chose to prosecute him. I felt like they could have. When he sued corporations and required them to donate money to the U.S. or to the Texas University's LBJ School of Government, which hired him to teach there. He required them to do that so he would dismiss the criminal charges against them. Although he wasn't prosecuted, people that made the laws in Texas realized those are the kind of things that should be inappropriate. So we're not trying to protect corporate polluters. We're just trying to make sure money doesn't go to the wrong places. I've had people crying out to me saying, why would we pay this to a place that is not going to fix the problem that they say we created? So I appreciate the immense devotion and concern, and yes, I'll deal with
I thank the gentleman for yielding, and I take his point. And I want to give another example to the gentleman from Georgia, and that is we had a very clear example of this abuse when the Justice Department properly prosecuted a bank that was laundering money for terrorists, and they wanted to take the proceeds of that money, a large, huge sum of money, and spend it on indirect things that they thought were a priority. But the Congress in that case interceded and took the money and actually spent it on actual victims of state-sponsored terrorism. The Congress should make these decisions, not the bureaucrats and not the prosecutors. This is not just to excuse any of these prosecutions, the victims of these, the perpetrators of these acts. They should suffer the same consequences, but the money that doesn't go to direct victims should come back into the general treasury, and the Congress should appropriate the funds. Maybe it will be related to something that concerns us regarding the underlying case in terms of pollution or other things like that, or maybe it'll be spent on another priority. The issue, however, is that the elected representatives of the people have a duty, a sworn duty, to uphold the Constitution and Article 1 of the Constitution that says the Congress shall appropriate funds, not bureaucracies, not prosecutors. And for that reason, the gentleman is absolutely correct, and I yield back to him.
And I appreciate the chairman's more articulate response than what I had, but I would yield the rest of my time to my friend from Colorado, Mr. Buck.
Thank you. I wanted to just respond to my colleague on the other side of the aisle who is accusing us of trying to help corporate polluters. I'm not sure if he realizes that we have $20 trillion of debt right now. We have $100 trillion of unfunded liabilities in this country, and any money that can go into the U.S. Treasury is money that our grandchildren will not have to pay on our irresponsible behavior. And I think it is unfortunate that my colleague is accusing folks of helping corporate polluters when the truth is that elected representatives have a duty to spend that money properly, and we have the duty to try to make sure we reduce our debt. I yield back.
Mr. Chairman.
Of course, the gentleman from Washington.
To strike the last word.
Gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman. I yield to my colleague from Georgia.
Thank you. I am so sorry that I have offended the feelings of my colleagues on the other side of the aisle, but I must respectfully point out that protecting corporate polluters is exactly what this bill would do, because if you ever diverted these indirect settlements to the Treasury under Republican control, and Republicans don't see climate change as being an issue. So when it comes down to these big corporate pollution lawsuits that result in billions and billions and billions of dollars, not even reflecting, by the way, the profits of the wrongdoers, but just breaking off a piece of those profits and giving back some of those ill-gotten gains to the appropriate plaintiff, be it private or a public entity, such as the EPA, which you all want to get rid of. I mean, if you put this money into the hands of the legislative branch, and it's not going to go to environmental remediation, it'll go for other things like war, like weapons of war, like nuclear weapons, and so the American people see through these pompous protestations. They understand the long record of protection of corporate polluters that has us in trouble in this country, and we have to do something about it. When the legislative branch doesn't move, that's why we have a co-equal branch of government, the judiciary. Justice is what taking a case to court is all about. And when a plaintiff gets justice, justice in a civil proceeding is in the form of pocketbook. Money is from your pocketbook. And so that money should be directed to the harm that was done, that was addressed in the underlying legislation. And courts have routinely noted that the purpose of the laws that have already been passed, these environmental laws have already been passed by Congress, and when a lawsuit is filed, the purpose of the reward is not to endow the Treasury, but is to actually go towards remediating the harm. And so that's what is so objectionable about H.R. 732. And that's why I urge my colleagues to vote no on this legislation. But before you do it, support this. And by the way, pompous protestations was not directed towards any of the members personally, but it was about this bill. And so with that, I will yield back the balance to Ms. Jayapala. Jayapala.
Does the gentlewoman yield back her time? Question occurs on the amendment. All those in favor respond by saying aye. Aye. Those opposed, no. No. Opinion of the chair, the noes have it. The amendment is not agreed to. Recorded vote is requested, and the clerk will call the roll.
Mr. Goodlatte?
No.
Mr. Goodlatte votes no. Mr. Sensenbrenner? Mr. Smith? Mr. Shabbat? Mr. Issa? Mr. King? Mr. Franks? Mr. Franks votes no. Mr. Gomert? Mr. Gomert votes no. Mr. Jordan? Mr. Poe? Mr. Chaffetz? Mr. Chaffetz votes no. Mr. Marino? Mr. Gowdy? Mr. Gowdy votes no. Mr. Labrador? Mr. Farenthold? Mr. Farenthold votes no. Mr. Collins? Mr. Collins votes no. Mr. DeSantis? Mr. Buck? Mr. Buck votes no. Mr. Ratcliffe? Mr. Ratcliffe votes no. Mr. Bishop? Ms. Roby? Ms. Roby votes no. Mr. Gates? Mr. Johnson? Mr. Johnson votes no. Mr. Biggs? Mr. Biggs votes no. Mr. Conyers? Mr. Conyers votes aye. Mr. Nadler? Mr. Nadler votes aye. Ms. Lofgren? Ms. Jackson-Lee? Mr. Cohen? Mr. Johnson? Mr. Johnson votes aye. Ms. Chu? Mr. Deutsch? Mr. Gutierrez? Ms. Bass? Mr. Richmond? Mr. Jeffries? Mr. Cicilline? Mr. Cicilline votes aye. Mr. Swalwell? Mr. Swalwell votes aye. Mr. Liu? Mr. Raskin? Mr. Raskin votes aye. Ms. Jayapal? Ms. Jayapal votes aye.
The gentleman from California, Mr. Issa.
Mr. Issa votes no.
Gentleman from Michigan, Ms. Bishop.
Mr. Bishop votes no.
The gentlewoman from California, Ms. Bass.
Ms. Bass votes aye.
The gentleman from California, Mr. Liu.
Mr. Liu votes aye.
Has every member voted? The gentleman from Florida, Mr. Deutsch.
Mr. Deutsch votes aye.
Has every member voted who wishes to vote? Clerk will report.
Mr. Chairman, 10 members voted aye, 14 members voted no.
And the amendment is not agreed to. Are there further amendments? For purposes, the gentleman from Rhode Island seek recognition.
Mr. Chairman, I have an amendment at the desk.
Clerk will report the amendment.
Amendment to H.R. 732 offered by Mr. Cicilline. Page 2.
Without objection, the amendment is considered as read, and the gentleman is recognized for 5 minutes on his amendment.
Thank you, Mr. Chairman. My amendment would exempt H.R. 732, my amendment would exempt from H.R. 732 any settlement agreement that directs funds to reduce the effects of the mortgage foreclosure crisis through foreclosure prevention assistance programs. There's a little debate that predatory and fraudulent activity in the residential mortgage securities market was the primary cause of the mortgage foreclosure crisis. As U.S. District Court Judge Max Cogburn observed in 2014, one need not, quote, be an expert in economics to take notice that it was the trading of toxic residential mortgage-backed securities between financial institutions that nearly brought down the banking system in 2008, end quote. The financial crisis blighted entire cities and communities, resulting in more than 13 million Americans losing their homes between 2006 and 2014, an average of 850,000 Americans per year. Beyond the life-changing hardship and stress placed on families by unlawful conduct in the housing market, the exponential rise in foreclosures imposed significant external costs on families and communities across the country. Fraudulent activity in the housing market depressed home and commercial real estate values, undermined economic development and municipal revenue, deprived communities of public services, and resulted in increases of violent crimes in communities with significant foreclosure activity. Leading studies have also documented the contagious effects of foreclosures, not just the neighborhood immediately affected by foreclosures, but nearby vicinities as well, underscoring the diffuse and systemic impacts of unlawful mortgage securities practices. In response to the financial crisis, President Obama announced in 2012 the creation of an investigatory unit within the Justice Department to, quote, hold accountable those who broke the law, speed assistance to homeowners, and help turn the page on an era of recklessness that hurt so many Americans, end quote. This unit secured more than $40 billion in civil penalties, compensation, and consumer relief to settlements with 5 financial institutions: Bank of America, Citigroup, Goldman Sachs, Morgan Stanley, and J.P. Morgan Chase, for alleged misconduct involving the packaging, marketing, and sale of residential mortgage-backed securities. Jeffrey Graber, who directed this effort within the Justice Department, testified in 2015 that these settlements meaningfully address the vicious cycle of harm caused by fraud in the housing market by, quote, achieving accountability for financial institutions that engage in wrongdoing relating to residential mortgage-backed securities, and to the extent possible, bringing some measure of relief to homeowners who suffered as a result of the financial crisis, end quote. In addition to civil penalties, these settlements included statements of facts describing the pervasive fraud that permeated the mortgage market. In just one example, bank employees stated that he would not be surprised if half of these loans went down and that the bank should start praying. The settlements also include consumer relief provisions designed to enable many Americans to stay in their homes by directing funds to distressed homeowners, community reinvestment and stabilization, and income-based lending for borrowers who lost homes to foreclosure. The department's settlements with Citicorp and Bank of America additionally direct $50 million in funds to charitable housing council programs and legal aid organizations to provide counsel to homeowners entitled to relief under the settlement because they were directly affected by the fraudulent and predatory conduct of the settling banks. As the Center for American Progress says, these funds account for less than 1% of the overall amount of each settlement and will, quote, support services provided by housing counselors and other trusted intermediaries that enable consumers to access the consumer relief to which they are entitled under the settlements, end quote. At a time when President Trump is attempting to appoint Steve Mnuchin, the foreclosure king of California, as Secretary of the Treasury, this legislation would simultaneously upend the type of exact settlement relief designed to keep people in their homes by prohibiting the enforcement of any settlement agreement that seeks to remedy indirect harms caused by unlawful conduct. We should be doing everything in our power to keep American families in their homes. This amendment will at least preserve the ability to do that. I urge my colleagues to adopt this amendment, and with that, I yield back.
For purposes, the gentleman from Texas seek recognition.
I rise in opposition to the
The
amendment.
gentleman is recognized for 5 minutes.
Thank you. I do rise in opposition to the amendment, and I have good news that actually the bill we're taking up, it actually allows exactly what the gentleman would like to happen. What it will not allow is the Justice Department to redirect money to those who are not directly or proximately harmed. That's the language in the bill. In federal law right now, victims may be compensated under the bill that we're taking up. And the federal law currently defines victims to be those who are directly and proximately harmed. So the underlying bill sought to be amended addresses the problem. It just prevents the Justice Department from sending that money to those who were not proximately harmed by the conduct. It's not protecting any polluters. It's not protecting any offenders. It's just making sure that the money goes to the actual victims, or it goes to the U.S. Treasury, which we then in Congress can make sure goes to those who may have a more generalized harm. So I'm encouraged by the underlying bill. I think it's a terrific bill. And although I appreciate the gentleman's effort on behalf of the victims, I think it's fantastic news that actually the underlying bill will make sure the money goes to actual victims, and the amendment would actually allow it to go to others who didn't have direct and proximate harm from the conduct.
The gentleman yield?
Yes, I'd be glad to.
So I think the gentleman just said that the underlying settlements that my colleague on the other side of the aisle have conducted oversight over for the last 2.5 years, that this doesn't apply, that the bill in its current form, that was the whole impetus for introducing the legislation. So if it's in fact the case that it doesn't apply, then why are we considering the bill? And why aren't we following the lead of Mel Martinez, who served as Housing and Urban Development Secretary under President Bush, and the General Chairman of the Republican Party in 2008, and he said, and I quote, "There's no room in the housing debate for partisan politics, meaning the housing needs of this country really demand bipartisan cooperation." And he testified in 2005 that housing counseling has proven to be an extremely important element in both the purchase of a home and in helping homeowners keep their homes in times of financial distress. So why aren't we following the recommendation, the bipartisan recommendation of Secretary Martinez, who was chair of the Republican Party, HUD Secretary to President Bush, and you're now acknowledging that the very problem you claim caused this bill to be introduced, in fact, doesn't exist?
Well, I'm reclaiming my time. I'm not haven't admitted any such a thing. And in fact, the oversight we did made very clear, and from Natural Resources Committee that I'm on, we've seen these sue and settle agreements between Democratic operatives and people in a Democratic administration. It is a problem in existence, and this will prevent, and in fact, this is the bill that we're preparing and that I'm proudly going to vote for is going to help deal with future problems that we acknowledge have existed, that we found have existed, and we are not going to let money from the lawsuits that Justice Departments bring be directed to people who are not directly and proximately harmed by the conduct being pursued. So I appreciate the gentleman's secondary defense, but actually it misses the mark. The mark is this bill will solve the problem, make sure the money goes to victims and doesn't go to groups that were not directly harmed, and I yield back.
Mr. Chairman,
For the purpose of the gentleman from Michigan, seek recognition.
I rise in support of the amendment.
The gentleman is recognized for 5 minutes.
Thank you. Members of the committee, we should want to exempt settlement agreements concerning the fraudulent use of mortgage-backed securities. As a result of predatory loans, toxic mortgage securitization, and regulatory failure, the mortgage foreclosure crisis blighted entire cities. My city of Detroit was hit particularly hard. Across the nation, while destabilizing the home market and countless other industries. But the effect of foreclosures go far beyond simple economics. Since the start of the Great Recession, foreclosures have sent shockwaves throughout entire communities, taking children out of school, pulling families and friends apart, undermining religious congregations, and creating other forms of social instability. Now, it is therefore vital that the federal government not only hold fraudulent corporations accountable through civil and criminal settlements, but that these settlements also materially help the millions of consumers harmed by this unlawful conduct. H.R. 732 is premised on the misguided, I'm sorry to say, belief that the Justice Department's settlement agreements with Citigroup and Bank of America, banks that each admitted to fraudulently packaging, marketing, and selling residential mortgage-backed securities, even when they knew that the loans were defective or bad policy. To the contrary, these settlement agreements directed funds to distressed homeowners affected by the bank's fraudulent and predatory conduct. One could argue that these terms would squarely fit within the bill's exception for payments that remedy a direct and proximate harm. And indeed, as the Center for American Progress has clarified, these funds will support services provided by housing counselors and other trusted intermediaries that enable consumers to access the consumer relief to which they're entitled under the settlement. But as the Justice Department noted in its opposition to a prior version of this H.R. 732, this bill would unwisely constrain the government's settlement authority and preclude many permissible settlements that would advance the public interest. Without this amendment, H.R. 732 would certainly threaten to diminish the Justice Department's ability to advance the public interest. And so I urge my colleagues to consider favorably supporting this amendment. I yield back, Mr. Chairman.
Question occurs on the amendment offered by the gentleman from Rhode Island. All those in favor respond by saying aye.
Aye.
Those opposed, no. No. Seeing the chair, the noes have it. The amendment is not agreed to.
For a recorded vote, Mr. Chairman.
Board vote is requested, and the clerk will call the roll.
Mr. Goodlatte?
No.
Mr. Goodlatte votes no. Mr. Sensenbrenner? Mr. Smith? Mr. Shabbat? Mr. Isa? Mr. Isa votes no. Mr. King? Mr. Franks? Mr. Franks votes no. Mr. Gomer? Mr. Gomer votes no. Mr. Jordan? Mr. Jordan votes no. Mr. Poe? Mr. Chaffetz? Mr. Chaffetz votes no. Mr. Marino? Mr. Marino votes no. Mr. Gowdy? Mr. Labrador? Mr. Farenthold? Mr. Farenthold votes no. Mr. Collins? Mr. Collins votes no. Mr. DeSantis? Mr. Buck? Mr. Buck votes no. Mr. Ratcliffe? Mr. Ratcliffe votes no. Mr. Bishop? Mr. Bishop votes no. Ms. Roby? Ms. Roby votes no. Mr. Gates? Mr. Johnson? Mr. Johnson votes no. Mr. Biggs? Mr. Conyers?
Aye.
Mr. Conyers votes aye. Mr. Nadler? Aye. Mr. Nadler votes aye. Ms. Loughran? Ms. Jackson-Lee? Mr. Cohen? Mr. Johnson? Mr. Johnson votes aye. Ms. Chu? Mr. Deutsch? Mr. Gutierrez? Ms. Bass? Mr. Richmond? Mr. Jeffries? Mr. Cicilline? Mr. Cicilline votes aye. Mr. Swalwell? Mr. Swalwell votes aye. Mr. Liu? Mr. Raskin? Mr. Raskin votes aye. Ms. Jayapal? Ms. Jayapal votes aye.
The gentlewoman from California.
Ms. Bass votes aye.
Has every member voted who wishes to vote? The gentleman from Arizona.
Mr. Biggs votes no.
The gentleman from Florida, Mr. Gates. Gentleman from,
Mr. Liu votes aye.
how is the gentleman from Florida recorded?
Mr. Gates votes no.
Has every member voted who wishes to vote? Clerk will report.
Mr. Chairman, 9 members voted aye, 16 members voted no.
And the amendment is not agreed to. Are there further amendments
Mr. Chairman,
for the purpose of the gentlewoman from Washington
I
State?
move to strike the last word, and I have an amendment at the desk.
The clerk will report the amendment.
Amendment to H.R. 732 offered by Mr. Jayapal of Washington. Page 2, line 6.
Without objection, the amendment is considered as read, and the gentlewoman is recognized for 5 minutes on her amendment.
Thank you, Mr. Chairman. This amendment ensures This amendment exempts from H.R. 732 settlements that direct funds to provide assistance to current or potential homeowners, particularly for the purpose of providing foreclosure prevention assistance or instruction on avoiding predatory lending. In 2015, the Department of Housing and Urban Development certified over 2,000 housing counseling agencies that had counseled more than 1.3 million families. Some of these agencies include Catholic Charities, the National Urban League, and the National Council of La Raza. Across the country, these nonprofit housing counseling agencies were essential during the foreclosure crisis. They are trusted sources of information in the community, and particularly in these communities that bore disproportionate burden and were targeted by predatory lending practices. For many homeowners who are about to lose their home, they desperately need somebody who can help them to understand the process and their options. Ultimately, Mr. Chairman, unfortunately, even with the help of some of these housing counseling agencies, more than 2.5 million people lost their homes to foreclosure in the 3 years that followed the burst of the housing bubble. And between 2007 and 2010, 8% of Latino families lost their homes, compared with 4.5% of white families. And in addition, Hispanic families lost 44% of their wealth. The September 2014 NeighborWorks America's evaluation for the National Foreclosure Mitigation Counseling Program showed that homeowners are nearly 3 times, that's 283%, more likely to get a modification if they receive housing counseling. And as a result, more than 96,000 NFMC clients secured a loan modification through housing counseling, modifications that they could not have secured on their own and that saved them about $478 million annually. Policymakers on both sides of the aisle have recognized the value of pre- and post-purchase counseling. Former Congressman James Walsh, Republican from New York, played an instrumental role in allocating funding to housing counseling. And former Senator Kip Bond, Republican from Missouri, has written a number of blog posts and editorials through his work with the Bipartisan Policy Center on the importance of early intervention to forestall financial disaster. These are just 2 examples out of so many who have spoken out about housing counseling's demonstrable benefit. If there's no objection, Mr. Chairman, I would like to submit for the record a letter from some of the organizations with their stated objections. I urge my colleagues to support this amendment to continue to provide these essential housing services to our communities across the country, and I yield back the balance of my time.
Without objection, the letter will be made a part of the record. For purpose, the gentlewoman from Alabama seek recognition.
Move to strike the last word.
Gentlewoman is recognized for 5 minutes.
I oppose this amendment would exempt funding for HUD-approved housing counseling agencies from the bill's ban on third-party payments. And this is ironic because such funding arrangements are precisely why this bill is needed. The bill's guiding principle is that once direct victims have been compensated, deciding to do what to do with the additional funds extracted from defendants becomes a policy question properly decided by elected representatives in Congress, not agency bureaucrats or prosecutors. Congress already funds HUD-approved housing counseling agencies through the annual appropriations process. For DOJ to direct additional funding to those entities improperly augments their funding entirely outside of the congressional appropriations and oversight process. I urge all committee members to oppose this amendment on institutional grounds. I yield back.
Would the chairwoman yield? Would the member yield for a question?
I'll yield.
Thank you. Since this amendment does cover Catholic charities, faith-based organizations, I mentioned Catholic charities earlier, is it your position that even Catholic charities constitute a slush fund?
The position is, and I'm reclaiming my time, the position is Congress already funds HUD-approved housing counseling agencies through the appropriations process in a specific line item. I yield back.
For purpose, the gentleman from New York seek recognition.
Strike the last word.
Gentleman is recognized 5 minutes.
Mr. Chairman, we know, first of all, let me congratulate the gentlelady from Washington on this excellent amendment. Let me say that we know, as she said, that the horrible impact of foreclosures on so many people after the Great Recession in 2007 to 10. We know that this Congress bailed out the banks. One can debate whether we should or not, but we did. I think we had no choice, but we did. We have not done nearly the same justice to victims of foreclosure. Now, it is true that we do fund housing assistance groups to help you with foreclosure. It is also true, as the gentlelady said, that people who have such help avoid foreclosure to a much greater extent than people without such help. And it is also true that there's a long waiting list for such help, and that the amount of funding that this Congress has provided for such groups is greatly underneath what is necessary, as shown by the fact of the long waiting list and the huge number of people with foreclosures who cannot be helped. So approving this amendment would be precisely an exercise of congressional judgment on this matter, the kind of congressional judgment that Roby says we should exercise, and she's right, but we should exercise it here. We can do it on the merits here. We know here that what the appropriators have given is much too inadequate, and that if funds can be made available, funds are available as a result of settlements, they would be very well utilized here, and we would save a lot of middle-income and low-income homes from foreclosure, and would be a little less subject to the charge that we bailed out the banks, but not the homeowners. A charge which has a great deal of validity at this point. So I would hope we would exercise our congressional judgment, our political and congressional substantive judgment on this matter in favor of this amendment, and that is our proper role. I yield back.
The gentleman yield.
Sure.
I just want to comment on the gentleman's circular logic here. He says the gentlewoman from Alabama is correct, that this is the province of the Congress to appropriate. The Appropriations Committee has appropriated, but not enough money. So by abandoning Congress's authority, by adopting this amendment, and therefore giving up the authority to put a check against bureaucrats and prosecutors appropriating in our place, we are effectively
reclaiming my
appropriating. And I think that's circular logic, and I'm going to call the gentleman on it.
Reclaiming my time, it is excellent logic, in my opinion. What we are saying, what it is saying is that Congress has more than one means of making money available to where it sees the necessity for making funds available. We can do it through a direct appropriation, or knowing the failure to supply sufficient funds through direct appropriation, we can do it this way, and that too is an exercise of valid congressional judgment. I yield back.
Well, let's put it to a vote.
Mr. Chairman.
Actually, the gentleman from Rhode Island wants to intervene before we vote on that.
I do. I'm hoping to make one final
Gentleman's
argument.
recognized for 5 minutes.
Thank you, Mr. Chairman. I strongly support this amendment. Thank the gentlelady from Washington for offering it. It addresses one of my principal concerns with H.R. 732, namely that it's premised on misguided and unsupported rhetoric rather than on fact or sound public policy. Since 2014, the majority has pursued a partisan and conclusory investigation into the Justice Department's settlements with several banks engaged in fraudulent activity in the residential mortgage-backed securities market. Notwithstanding the voluminous production of documents, including emails of the attorneys who negotiate these settlement agreements, there has been no evidence produced suggesting a political agenda of the Justice Department. Instead, we've uncovered numerous documents that illustrate time and time again that the Justice Department had a singular purpose in settling these cases: to hold unlawful conduct accountable, to make consumers whole. It's also important to note that none of the settling banks disputes that their conduct harmed consumers. In fact, each of the settlements contained a statement of facts that described in detail the culpable conduct of each bank that contributed to the collapse of the residential-backed securities market. Professor Alan White, a legal expert on the mortgage market, debunked the majority's premise for the bill, noting that these settlements, quote, are critical to home ownership preservation and full housing market recovery, while funds directed to legal services and housing counselors always comes with necessary oversight, auditing, and reporting to prevent misuse of funds. I've seen this firsthand in my own state with outstanding foreclosure prevention assistance programs. I'm also disturbed that the majority's investigation has largely targeted minority organizations with housing council programs, such as the National Council on La Raza and the National Urban League, rather than the many other charitable and local organizations that also have housing counseling programs. Nevertheless, as La Raza has noted, its network of expert housing counselors and all HUD-certified housing counselors play a crucial role as third parties that offer unbiased information and advice to homeowners, homebuyers, renters, and victims of predatory lending, and families facing a financial emergency. This is particularly for Latino families who are among the hardest hit by the mortgage foreclosure crisis. Mark Morial, the president and CEO of the National Urban League, has similarly stated that, quote, the success of housing counseling programs provided by the National Urban League and others are undisputed. Borrowers who have used housing counseling are 1/3 less to be seriously delinquent on their loan payments, and those who are in default are 60% more likely to save their homes, end quote. Claims that these services are slush funds, Mr. Morial concludes, quote, is an egregious and shameless attempt to smear and impugn the integrity of long-standing and trusted nonprofits and civil rights organizations, end quote. Mr. Chairman, support for the HUD-certified housing council organizations need not be a partisan issue. Mel Martinez, who served as Housing and Urban Development Secretary under the George W. Bush administration and chairman of the Republican Party from 2006 to 2007, stressed in testimony before the House Committee on Financial Services in 2005 that, quote, housing counseling has proven to be an extremely important element in both the purchase of a home and in helping homeowners keep their homes in time of financial stress, end quote. And accordingly, I urge all of my colleagues to support this excellent amendment and do right by our constituents and be sure that they continue to have access to this necessary counseling that will help to stabilize neighborhoods and keep families in their homes. And with that, I yield back.
Question occurs on the amendment offered by the gentlewoman from Washington. All those in favor respond by saying aye. Aye. Those opposed, no. No. Being the chair, the noes have it. The amendment is not agreed to.
May I ask for a recorded vote, Mr.
Recorded vote is requested, and the clerk will call the roll.
Mr. Goodlatte?
No.
Mr. Goodlatte votes no. Mr. Sensenbrenner? Mr. Smith? Mr. Shabbat? Mr. Issa? Mr. Issa votes no. Mr. King? Mr. Franks? Mr. Franks votes no. Mr. Gomert? Mr. Gomert votes no. Mr. Jordan? Mr. Jordan votes no. Mr. Poe? Mr. Chaffetz? Mr. Chaffetz votes no. Mr. Marino? Mr. Marino votes no. Mr. Gowdy? Mr. Gowdy votes no. Mr. Labrador? Mr. Farenthold? Mr. Farenthold votes no. Mr. Collins? Mr. Collins votes no. Mr. DeSantis? Mr. DeSantis votes no. Mr. Buck? Mr. Buck votes no. Mr. Ratcliffe? Mr. Bishop? Mr. Bishop votes no. Ms. Roby? Ms. Roby votes no. Mr. Gates? Mr. Gates votes no. Mr. Johnson? Mr. Johnson votes no. Mr. Biggs? Mr. Biggs votes no. Mr. Conyers?
Aye.
Mr. Conyers votes aye. Mr. Nadler?
Aye.
Mr. Nadler votes aye. Ms. Lofgren? Ms. Jackson Lee? Mr. Cohen? Mr. Johnson? Mr. Johnson votes aye. Ms. Chu? Mr. Deutsch? Mr. Gutierrez? Ms. Bass? Mr. Richmond? Mr. Jeffries? Mr. Cicilline? Mr. Cicilline votes aye. Mr. Swalwell? Mr. Swalwell votes aye. Mr. Liu? Mr. Raskin? Ms. Jayapal? Ms. Jayapal votes aye.
Has every member voted who wishes to vote? Clerk will report.
Mr. Chairman, 6 members voted aye, 17 members voted no.
And the amendment is not agreed to. Are there any other amendments to H.R. 732? A reporting quorum being present, the question is on the motion to report the bill H.R. 732 as amended favorably to the House. All those in favor respond by saying aye. Aye. Those opposed, no. No. The ayes have it, and the bill is ordered reported favorably.
We have a
Recorded vote is requested, and the clerk will call the roll.
Mr. Goodlatte?
Aye.
Mr. Goodlatte votes aye. Mr. Sensenbrenner? Mr. Smith? Mr. Shabbat? Mr. Issa? Mr. Issa votes aye. Mr. King? Mr. Franks? Mr. Franks votes aye. Mr. Gomert? Mr. Gomert votes aye. Mr. Jordan? Mr. Jordan votes yes. Mr. Poe? Mr. Chaffetz? Mr. Marino? Mr. Marino votes aye. Mr. Gowdy? Mr. Gowdy votes yes. Mr. Labrador? Mr. Farenthold? Mr. Farenthold votes aye. Mr. Collins? Mr. Collins votes aye. Mr. DeSantis? Mr. DeSantis votes aye. Mr. Buck? Mr. Buck votes aye. Mr. Ratcliffe? Mr. Bishop? Mr. Bishop votes aye. Ms. Roby? Ms. Roby votes aye. Mr. Gates? Mr. Gates votes aye. Mr. Johnson? Mr. Johnson votes aye. Mr. Biggs? Mr. Biggs votes aye. Mr. Conyers?
no.
Mr. Conyers votes no. Mr. Nadler? No. Mr. Nadler votes no. Ms. Lofgren? Ms. Jackson Lee? Mr. Cohen? No. Mr. Cohen votes no. Mr. Johnson? Mr. Johnson votes no. Ms. Chu? Mr. Deutsch? Mr. Gutierrez? Ms. Bass? Mr. Richmond? Mr. Jeffries? Mr. Cicilline? Mr. Cicilline votes no. Mr. Swalwell? Mr. Swalwell votes no. Mr. Liu? Mr. Raskin? Ms. Jayapal? Ms. Jayapal votes no.
The gentleman from Utah.
Mr. Chaffetz votes aye.
Has every member voted who wishes to vote? Clerk will report.
Mr. Chairman, 17 members voted aye, 8 members voted no.
The ayes have it, and the bill is ordered reported favorably to the House. Members will have 2 days to submit views. Without objection, staff is authorized to make technical changes to complete the addition of the amendments to the bill. This completes the business of the committee for today. I thank all the members for attending and their participation. The markup is adjourned.
Thank you.
Thank you, sir.